Hello and welcome to this UK Lawyers for Israel Charitable Trust event on the Ben & Jerry's saga. Thank you all for joining from different parts of the world. We are delighted that this webinar has been sponsored in memory of Shirley and Harold Tucker, and we're extremely grateful to the sponsors for their generous support. Last year, Ben & Jerry's, a subsidiary of Unilever, decided its ice cream should no longer be sold in East Jerusalem, Judea, and Samaria, claiming this to be, quote unquote, inconsistent with our values, and sought to terminate the long-standing Israeli licensee who would not accept this policy. Unilever subsequently sold the Ben & Jerry's brand in Israel to the licensee, enabling the licensee to continue distributing the ice cream in Israel and its territories. Ben & Jerry's board has now sought to block this sale in court, claiming that its parent, Unilever, is breaching the merger agreement between the two companies. In just the last 2 days, a US district judge hearing this matter, Andrew Carter of the Southern District of New York, denied Ben & Jerry's request for an injunction in a ruling which said that the company's arguments were too speculative. I am thrilled to be introducing Professor Jesse M. Fried, who is one of the world's leading experts on corporate law, corporate governance, and securities regulation. He has written several important articles on the Ben & Jerry's saga and will be giving us his views shortly on where we stand and what this means for BDS, as well as corporate governance more generally. Professor Jesse Fried is the Dane Professor of Law at Harvard Law School. Before joining the Harvard faculty in 2009, he was a professor of law and faculty co-director at the University of California Berkeley Center for Law, Business, and the Economy. Professor Fried has been a visiting professor at Columbia University Law School, Duisenberg School of Finance, Hebrew University, IDC Herzliya, and Tel Aviv University. He holds an AB and AM in economics from Harvard University and a JD magna cum laude from Harvard Law School. We're absolutely thrilled to be having him tonight to address us. A few housekeeping points before we begin. You are all warmly invited to submit questions for Professor Fried. There is a Q&A box at the bottom of the screen, and do please type your questions there. I will then relay these questions to Professor Fried at the end of his presentation. All questions will be put to Professor Fried anonymously. Professor Fried, the floor is yours.
Thank you very much, Jacob, for that very kind introduction. I'm very pleased to be here to talk about the Ben & Jerry's saga as seen from my perspective in Cambridge, Massachusetts. By way of background, I advise several groups of lawyers who sued or are about to sue Unilever this summer, but aborted at the last moment because Unilever reversed the boycott. And I had an important partner in this effort, Professor David Weber of Boston University, a securities law specialist, who reached out to me when Ben & Jerry's announced its boycott in July of 2021 and asked me to join with him to see what we could do to help reverse the boycott. He and I, and especially he, plowed through lots of corporate documents, so I want to acknowledge David for his many contributions. I also want to say that any errors I make in this presentation are entirely my own. So let me start at a very high level to provide context to the Ben & Jerry's boycott. As you know, Israel's enemies have failed so far to destroy Israel on the battlefield, but they've not given up their goal of destroying Israel. So they're switching tactics. They're trying to erode support for Israel in the West by demonizing it and weakening it economically. Their hope is that Israel will capitulate and collapse, much as South Africa did in response to external pressure. This effort now goes by the name of the Boycott, Divestment, Sanctions, or BDS movement, which started about 20 years ago. This movement has had some success with academic boycotts. There are some open boycotts of Israeli academics and Israeli academic institutions, and there are many silent boycotts of Israeli academics and Israeli academic institutions. Israeli academics are locked out of conferences and not published in many journals because of their nationality. BDS has also had some success with cultural boycotts, getting singers to cancel performances and the like. In the economic sphere, BDS seems to have had limited success, although there probably are some firms that are silently not doing business with Israel because they fear the BDS movement. Although the movement has not had much success in the economic realm so far, we can't be complacent. Things can change, and Israel is quite vulnerable to an economic boycott. Israel is essentially an economic island. It relies very heavily on imports and exports. And Europe is its most important trading partner by dollar volume, and also many important infrastructure technologies that Israel wants are available in Europe and not so available elsewhere. Unfortunately, Europe is where the BDS forces are strongest. If Europe were to cut off trade with Israel, it would be extremely damaging. Israelis are very cosmopolitan. They often hold two passports. Businesses can be run anywhere. If Europe started to tighten the screws, many talented people will leave, and Israel would be badly hurt. Because of the potential threat of BDS, in the last 10 years or so, Jewish groups in the United States have lobbied individual states to adopt anti-BDS laws, and about 35 have done so. The idea is to deter businesses from boycotting Israel. Here's how they work. In some states, the law requires that if state funds are being invested in the stock or bond market, that those funds cannot be used to buy the shares or bonds of any company that boycotts Israel. In other states, there's a law that says that if you, as a business, are contracting with a state, you have to attest that you're not boycotting Israel. And some states have both kinds of provisions. Now, these laws have some limits. States generally own very few shares of individual companies relative to large asset managers. And if they sell their shares or bonds, it is typically just going to be a drop in the bucket. Others will buy those securities and the price won't be affected, certainly in the long run, probably not in the short run either. The contract laws have bite only if boycotting companies contract directly with a state. A boycotting company might sell to the state through intermediaries, and the intermediaries can certify that they are not boycotting Israel. Unilever is an example of a company that does not sell directly to states, even though many states buy its products because it sells through intermediaries. However, these laws are still quite powerful. Companies do not want to have states loudly dumping their shares. They fear potential pressure on big asset managers to dump their shares. And even if companies do not now directly contract with states, they may wish to do so in the future. Now, these laws are in the United States, but they have, in my view, a large effect in Europe. Suppose that BDS protesters show up at European companies and say, we don't like the fact that your goods or services are being sold in Israel. It contributes to apartheid, genocide, or whatever they're going to say. The CEO can say, hey, we're sympathetic to your cause, but we can't boycott Israel because if we do, we're going to lose lots of business in the United States and we're not going to be able to raise capital as easily in the US markets. So sorry, we can't help you. So even though these laws were enacted in the United States, they can have a powerful effect in Europe where Israel is the most vulnerable. And that's why you don't hear many companies openly boycotting Israel. One notable exception in recent years is Airbnb, which came under pressure from the BDS movement before going public in 2019. It said it would stop offering its services in the West Bank in Jewish towns in Judea and Samaria. After that, states announced they would not buy Airbnb shares in the IPO. There were lawsuits that were filed by guests and hosts against Airbnb, and then Airbnb backed down before it went public. So now let's turn to Ben & Jerry's. So as Jacob said, Ben & Jerry's is a subsidiary of Unilever, which acquired it in 2000. In July of 2021, Ben & Jerry's announced that it would not be renewing its license with Israeli licensee Avi Zinger at the end of 2022, even though it had had a 30-plus year relationship with him. Why? Because, Ben & Jerry's said, it believed that selling ice cream under the Ben & Jerry's brand in what it deemed the occupied Palestinian territories is inconsistent with Ben & Jerry's, quote, brand integrity, quote, and social mission. Now, somewhat cryptically, Ben & Jerry's also said, we will stay in Israel under a different arrangement. Unilever, the parent, issued its own statement. It said, this decision to not renew the license was a decision of Ben & Jerry's, quote, independent board, unquote, which Unilever had respected in the past, or whose decisions Unilever had respected in the past. Unilever said it was pleased that Ben & Jerry's would stay in Israel under a different arrangement. Unilever emphasized that it was committed to its many businesses in Israel, which employ thousands of people and in which it had invested millions of dollars. So Unilever's statement suggested that Unilever's board was not really happy with Ben & Jerry's board's decisions, but was willing to go along with it. But then after these statements were issued, the chair of Ben & Jerry's independent board, Anuradha Mittal, says that the independent board does not want Ben & Jerry's to stay in Israel, and it did not agree to a commitment to stay in Israel, and that the press release that was released did not reflect the Ben & Jerry board's decision. So this is a very odd situation. You have a subsidiary of a conglomerate rebelling against the parent, and every other subsidiary on the planet, the parent would have full control over the actions of the subsidiary because it would appoint every member of the board, or at least a majority. The Ben & Jerry's board wanted to release a particular press release, but Unilever was somehow able to alter it by saying, we will remain in Israel. Then there's the cryptic line that they're going to remain in Israel. How can Ben & Jerry's both remain in Israel and not sell in Judea and Samaria? Israeli law prohibits discrimination based on location. A business cannot sell in pre-67 Israel, but refuse to sell in Judea and Samaria, the Golan Heights in East Jerusalem. So what is going on? To understand what's going on, we need to look under the hood of Ben & Jerry's governance arrangements. In 2000, Unilever purchased all of the shares of Ben & Jerry's. Prior to 2000 and till this day, Ben & Jerry's marketed itself and continues to market itself by aligning with left-wing and progressive social causes. It takes public stands on various political issues, and it makes a point of buying from certain vendors and not others. For example, it buys from local dairy farmers practicing sustainable agriculture in Vermont, even though that may not be the cheapest source of milk. So apparently, Unilever, in order to get the individual founders, the human beings, Ben & Jerry, to agree to the sale, Unilever had to agree to a unique governance mechanism. The mechanism works as follows. Ben & Jerry's would have a board of directors. A majority of them would be independent directors, that is not Unilever appointed. These directors are self-perpetuating. So when one steps down, this group of independent directors appoints a successor. Because they are a majority, the board is controlled by these independent directors. The board of directors has, quote, primary responsibility for preserving and enhancing, unquote, the social mission of the company. They are supposed to be the custodians of Ben & Jerry's brand image. They're supposed to safeguard the integrity of essential elements of Ben & Jerry's brand name. However, Unilever is mostly in charge. Unilever appoints the CEO, who controls all of the employees of Ben & Jerry's and all of the money that Ben & Jerry's has. Unilever is given financial and operational authority over Ben & Jerry's, and all powers that are given to Unilever, all powers are given to Unilever except those expressly given to the board, including sales of assets. So what happened? Well, the independent board at Unilever got along for many years until BDS activists showed up. In 2013, 2014, the independent directors of Ben & Jerry's began coming under pressure from BDS activists. This continued for several years. A few years ago, Ben & Jerry's tried to pressure Avi Zinger to stop selling Ben & Jerry's ice cream in what it deemed to be the occupied Palestinian territories. Zinger refused, probably on principle, but also not selling ice cream in Judea and Samaria would violate an Israeli law that forbids discrimination against customers based on geographic location. So Zinger refused to go along with this, and he said he was going to sell ice cream everywhere. In July of 2020, the Ben & Jerry's board passed a resolution to take steps such that Ben & Jerry's ice cream would no longer be sold in what it called the occupied Palestinian territories. This resolution was not made public at the time, but it was revealed later. And essentially what the board decided was not to renew Zinger's license, because that's the only way to stop selling ice cream in the occupied Palestinian territories, as it called them, is to not have ice cream sold anywhere in Israel. But the CEO of Ben & Jerry's in July of 2020, who, remember, is appointed by Unilever and as operational control, refused to implement the board's decision. In July of 2021, Unilever relented and finally let Ben & Jerry's announce a non-renewal of the Zinger license. But Ben & Jerry's CEO, who's a Unilever appointee, apparently wrote the press release for Ben & Jerry, which said that although the license would not be renewed, Ben & Jerry's would find another way to keep Ben & Jerry's ice cream in Israel, even though that was not the intention of the independent board or the wish of the independent board. Now, apparently at the time, we now know Unilever had some ideas in mind for keeping Ben & Jerry's in Israel, and perhaps they had in mind the solution that they ultimately used in 2022. So after this boycott was announced, there were swift reactions. Many states announced that they were divesting from Unilever stocks and bonds, or they were putting Unilever on a watch list and would divest depending on how things played out. Unilever stocks started falling. In part, this was due to the controversy, but in large part, it was due to very bad operating results that they had just released. Unilever was criticized by a number of senators who wrote to the SEC, our securities regulator, to express concern. And as in Airbnb, complaints and lawsuits were filed against Unilever or were in preparation, which, as I said before, I helped advise some of them. So in Israel, Zinger filed a complaint with the Israel Antitrust Agency, claiming that Unilever was in violation of a 2001 consent decree approving the Ben & Jerry's merger as it affected Israel. So let me unpack that a little bit. Before 2000, until this day, Unilever owned another ice cream distributor in Israel. Before 2000, Ben & Jerry's was independent of Unilever. So the Israeli Antitrust Authority was worried that if Unilever also controlled Ben & Jerry's, in addition to the ice cream distributor it already controlled, there could be price collusion between the two distributors. So the Antitrust Authority had the power to either allow the merger or forbid it. And it used that power to put conditions on the 2000 merger relating to Israel. It then signed off on the merger. So in 2021, when Zinger complained to the antitrust agency that Unilever was in breach of these conditions, the antitrust agency signaled to Unilever that it was likely in breach by not renewing Zinger's license. There were 2 class action lawsuits brought in Israel. In March 2022, Zinger sued Ben & Jerry's and Unilever in New Jersey federal court for breach of contract. A securities class action suit was filed in mid-June of 2022 against Unilever, alleging that it hid the July 2020 decision to boycott Israel, and the disclosure of the decision in July 2021 caused the stock price to drop, harming investors who had bought the shares during the preceding year when the decision to boycott Israel was hidden from them. There was another suit, a derivative suit bringing claims under UK corporate law that was going to be filed in New York State Court that was aborted when Unilever announced in late June of 2022 that it had reached a solution where Zinger would be allowed to operate Ben & Jerry's in Israel. In addition to these lawsuits, something else was happening that was just as important, if not more important. A very well-known activist hedge fund, Trian, started accumulating shares in Unilever after its price had fallen in mid to late 2021. Now, Trian is run by a guy named Nelson Peltz, who is pro-Israel and sits on the board of the Simon Wiesenthal Center. As early as September of 2021, Peltz was lobbying the CEO of Unilever to reverse the boycott. And in spring of 2022, Unilever announced that Peltz would go on the board. Even before Peltz went on the board, he had a lot of influence over Unilever because of his ownership position and credibility. So Unilever was subject to a lot of pressure. There were these legal cases, possible confrontation with the Israeli antitrust agency, state divestments, and then Nelson Peltz, who has a lot of power in the company, shows up and is urging the board of Unilever to take steps to reverse the boycott. So in late June 2022, Unilever decided to enter into a transaction that basically allowed Zinger to continue operating his business in Israel and the territories. In this transaction, Ben & Jerry's trademarks in Hebrew were sold to him or transferred to him, along with the rights to register certain other trademarks in Hebrew and Arabic. This, along with a bunch of other elements of the transaction, which have not been publicly disclosed, would basically allow Zinger to do exactly what he's doing now, except he can't use the Ben & Jerry's English trademark. One nice win for Zinger is that any new recipes developed by Ben & Jerry's in Vermont would have to be shared with Zinger. This deal was approved by the Israeli antitrust agency, which also indicated that any reversal would require their approval. The pro-Israel community was very satisfied by this outcome. The only deficiency from my point of view was that the English language trademark was not transferred. And this was obviously done by Unilever to try to satisfy the independent board. But the independent board was not satisfied. On July 1st, the board decided to sue Unilever for breach of its merger agreement, as Jacob said. On July 5th, the independent board filed a lawsuit in New York federal court seeking to enjoin or prevent Unilever from doing anything that would permit Ben & Jerry's products to be sold in the West Bank, even though the transaction had closed in late June. Now, an interesting fact is that the lawyers bringing the lawsuit are working on a contingency basis because while the CEO of Ben & Jerry's has access to cash to pay lawyers, the board does not. The lawyers representing the board sought a temporary restraining order on July 5th when they filed their lawsuit. Temporary restraining order is sort of like an emergency order to get the other side to stop doing whatever they're doing without giving the other side an opportunity to respond. That was denied by the judge the same day. The Ben & Jerry's board also asked for a preliminary injunction, which is like a restraining order, except it's briefed and argued by the parties. And it's designed to sort of freeze things pending a final decision by the court. They asked for that on July 5th. Yesterday, August 22nd, the court denied the preliminary injunction. But the case is still going on, and so we'll hear more about it. The likely outcome of this case is that if it were to proceed all the way, Ben & Jerry's is highly unlikely to win. Their legal claim is very weak. The trademarks were owned by Unilever, not by Ben & Jerry's, and the Ben & Jerry's board clearly has no rights to block actions by its shareholder Unilever. Even if the assets had been held by Ben & Jerry's and not Unilever, its social mission powers that it has through the merger agreement are written to be quite narrow. So their legal claims are very weak. The cat is out of the bag already. The assets have already been transferred. You can't really undo a closed transaction. And the court's not going to want to try to undo the closed transaction. If it required Unilever to yank the assets back, Zinger would fight in court and would win. The Israeli antitrust agency might go after Unilever, and the divestments would continue and other states might join. Even if Unilever were ordered to undo the transaction, it would have to litigate against Zinger, and it wouldn't try very hard. It would just settle the litigation for very little, and nobody would know exactly how hard it was trying. So there are many reasons why a court's not going to reach a conclusion that this deal should be undone. In my view, the most likely outcome is a settlement. Although Unilever would win if this case were litigated all the way, it does not want a public battle with the board. So my assessment is that Unilever will throw some kind of bone to the Ben & Jerry's board. At the very least, Unilever will give some money to the lawyers for the Ben & Jerry's board who are working on a contingency basis, as I said. Okay, one last item. What are the implications for corporate BDS? Well, just like in the case of Airbnb, lawyers and Jewish organizations mobilized to fight Unilever because it's extremely important to send a message to other corporations that engaging in BDS is very costly. This time, it was just about ice cream, admittedly very good ice cream. This is not of sort of strategic importance to Israel, but if other companies see that there's no cost to BDS, they too may cave, and Israel could be badly hurt if there's a domino effect and multiple companies start boycotting Israel. There was a clear message sent to all those who are paying attention that it's costly to try to boycott Israel. In my view, this message would have been effective even if Unilever had not caved at the end, but it's more effective because they did. I don't expect any more BDS surrenders, even temporary ones like Airbnb and Ben & Jerry's by public companies, at least in the short term, because Unilever is quite an unusual situation. There was this one-of-a-kind governance arrangement that created a situation where you have unaccountable individuals in the corporate hierarchy who are free to pursue their own agenda, no matter how destructive it is. There's no other company like that. Companies are not going to want to get into the same mess as Unilever, so this is not really a harbinger of things to come, at least in the short run. I'll stop here and I look forward to your questions.
Professor Fried, thank you for a fantastic presentation. It was really informative, and I think has really set us up for an interesting conversation. We've received lots of questions from the audience, for which we're very grateful, and do please keep sending them through in the Q&A box, as I will add more as we go on if people have them. One questioner has asked, you mentioned the various states which have anti-BDS laws, but that is not all of the US states. So is there a pattern among the states which have not signed up to the anti-BDS laws?
So that's a great question. Why have 35 states signed up and 15 states have not signed up? So there are basically two characteristics, or one or both of which you will find in states that have adopted anti-BDS laws. Either there's a large and influential Jewish population, or it's a Republican state that has a state government that is very pro-Israel. And one of the things that people outside the United States don't fully appreciate, and even many American Jews don't appreciate, is that some of Israel's most ardent supporters in the United States are not Jews, they're Christians. And there are many of them scattered throughout the country. So it's mostly Republican states and, states with large Jewish populations.
We have another questioner who asks, are the independent directors of Ben and Jerry's acting consistently with their fiduciary duties to the company? And the questioner continues, presumably the company, Ben and Jerry's, could sue these directors for putting their own personal political opinions ahead of the best interests of Ben and Jerry's, and certainly those of its parent Unilever.
So that's a great question. In this unique governance arrangement, the directors are instructed to preserve the reputation of Ben and Jerry's as a sort of progressive brand. And the idea is that that is done in service of Ben and Jerry's and their ability to sell ice cream. So the people inside Ben and Jerry's, or the founders, are of the view that one of the reasons why they're successful is that they have this sort of reputation of standing up for progressive causes and engaging in sort of humane purchasing practices. So from their point of view, they are doing what's right for Ben and Jerry's. And it would be hard for Unilever, having agreed to give these people these powers and these instructions, to sue them for breach of fiduciary duty, although they do owe a fiduciary duty to Ben and Jerry's. These directors do not owe any fiduciary duty to Unilever, which is a shareholder. And actually, technically, there's a U.S. domiciled company called Canopco, which is the owner of Ben and Jerry's, and Canopco in turn is owned by Unilever. So the fiduciary duties would not sort of run up the corporate chain to the Unilever parent.
You mentioned in your last answer, and a couple of times in your presentation, the unique and very unusual arrangement as between Ben and Jerry's and Unilever, whereby this retention of ethical control was retained by the company being acquired by a conglomerate. I can think of another situation where that has happened in recent years. That was where Google, as it then was, acquired the UK company DeepMind, which is a leading AI company. And it was a stipulation of that agreement that there was a similar ethical control that DeepMind would have over the use of its technologies. So whilst I appreciate that that is slightly different from the Unilever situation, I wondered whether you had any sense, particularly in a scenario where ESG, environmental and social governance controls, are becoming more of a concern for companies, whether there is any kind of growing trend of companies being acquired and seeking to assert these types of ethical controls over the acquirer, and what, if anything, that might mean for BDS going forwards.
You know, Ben and Jerry's is, I think, a unique corporation. It was founded by Ben and Jerry, and they were trying to make great ice cream and do good for the world. And it was a very profitable company. There were apparently multiple suitors for the company, and Unilever was able to buy the company because it agreed to this governance arrangement. As far as I know, this governance arrangement has not been replicated anywhere. And most people who are selling companies, most boards of directors, they're interested in getting the the highest sale price when they're selling the company. And if the company is incorporated in Delaware, which Ben and Jerry's was not, they're sort of required by law to get the highest possible price and do the best for shareholders. So, as a matter of sort of individual incentives and Delaware law, which is going to apply to most companies, you're not going to have some sort of arrangement where the seller would negotiate for this type of provision, because presumably the buyer is going to discount the price that it's paying for the company if it has to agree to this type of provision because of all the complications it can create. And at the time, they probably never imagined that the board would get the Unilever parent into such great trouble. But over the last 20 years, in order to keep peace with the independent board, Unilever has had to make some sacrifices in how Ben & Jerry's is run. So I don't think we're going to see any other company like this, or any other arrangement like this, at least in the United States.
Building on that question and the point that you've emphasized a couple of times now, that this was quite an extreme case, an audience member has asked, given that this was an extreme case where BDS may have had the strongest possible chance of success, and yet they still seem likely to lose in the challenge, albeit that it's not over yet, does this suggest now, the audience member asks, that BDS has completely lost in the real economy and is unlikely to stand chances of success going forward?
Well, I think in the short run, as I said, I don't see BDS having much success in the economic sphere. First of all, American companies are not going to be inclined to BDS. America generally is a much more pro-Israel country than any European country. And if a European company is thinking about engaging in BDS, they're going to run into a lot of problems in the United States when they try to sell their products or raise capital, just like Unilever did. So I don't think in the short run that we're going to see more of this. But just like anti-Semitism is eternal, so is the effort to weaken and destroy Israel. And, people in the BDS movement will look for other ways to get at Israel. And, they're constantly trying to reprogram people's minds to hate Israel. It had been starting in college, but now you have BDS materials working their way into high schools and even junior high schools. So there's an ongoing effort to reprogram people. And if enough people are reprogrammed to hate Israel, then, BDS can succeed.
Understood. So it remains important to be vigilant. And it's worth noting that some of the other work that advocates for Israel are doing involves seeking to stop these slanderous publications when they are distributed in schools and other sorts of educational institutions. We have another question from the audience, which takes us outside of the Ben & Jerry's situation and asks for your views on two other recent alleged BDS actions. And I say alleged because the companies concerned, unlike Ben & Jerry's, which has proudly trumpeted its BDS credentials, these companies have denied they were engaged in BDS, even though their actions may have suggested otherwise, and they have certainly been congratulated by BDS advocates for these actions. The companies that the audience member asks about are General Mills, which is, I think, a food manufacturer that announced it was pulling out of manufacturing in Israel, but claimed this was a business decision. And the other company is Morningstar, a publisher of financial information and analytics. And in particular, it was said that one of their subsidiaries called Sustain Analytics was advocating through its products and services a boycott of Israel, although it was recently found by the Illinois Investment Policy Board not to have actually been engaging in a boycott, despite having a disproportionate focus on Israel. So the questioner asks, with respect to these two situations, what are your views? Was anything done wrong, and what might be done about it?
So, as far as General Mills go, I'm not that familiar with what happened. My understanding is that General Mills closed some operation in Israel, but continues to operate others, although I'm not sure about that. One of the things that the BDS movement does is every time any business shuts down an operation in Israel, which it might do for commercial reason, it takes credit. So the BDS movement sort of, tries to pressure every company with ties to Israel. And then when one of them pulls back in Israel for commercial reasons, they take credit. So I assume that's what was happening. As for Morningstar, just to provide a little bit more background, Morningstar purchased an information provider called Sustainalytics, which helps people managing money to figure out like which companies may have environmental, social, or political risks attached. Sustainalytics algorithm, which is not public, seems to disproportionately focus on Israel, in part because it relies a lot on things that the UN produces, and the UN disproportionately focuses on Israel in a very negative way. So this, so basically what's happening at the UN is getting fed into this sort of data provider, and then it's going into like rankings of companies or recommendations for investment. So Jewish organizations approached Morningstar, which is the parent, and raised this issue. Morningstar brought in a very prominent law firm, White & Case, that did a review of Sustainalytics and basically gave Morningstar a clean slate, except for a few subcontractors of Sustainalytics, which White & Case recommended Sustainalytics stop using. So Morningstar is now saying that as a clean bill of health, but there are Jewish organizations that are not fully satisfied. And to my understanding, there's an ongoing effort to get Morningstar to do more.
A audience member points out with respect to the General Mills and subsidiary, which was called Pillsbury, that the family which founded Pillsbury has made public announcements to the effect that they support leaving Judea and Samaria and perhaps all of Israel. So I don't know whether that has affected the company's decision, or indeed whether they have any the founding family has any control in this matter. Is that a thing of which you're aware, and does it change your analysis at all?
I wasn't aware of that. I think I would have, if they were actually involved with Pillsbury still in an operational or governance capacity, I think I would have heard about it. So, they're basically off to the side, sharing with all of us their anti-Israel sentiment. And I think it's just a coincidence that General Mills and Pillsbury partially withdrew from Israel, and it's nothing to do with the fact that some members of the founding family don't like Israel.
Another audience member asks, aside from specific counter-boycott laws, which, as you have brought out in your presentation, can be very effective, are there any other laws or sanctions in the US against companies which control the actions of companies which operate purported ESG policies in a discriminatory manner?
So the only tools that we have to fight the BDS movement's attempt to get companies to boycott Israel are these state anti-BDS laws. There's a federal anti-boycott law, but it only applies to boycotts that are organized by governments. And the BDS efforts are not organized by a government, arguably. So the federal law has not been applied, or nobody's tried to apply the federal law to what the BDS movement is doing. this ESG story is evolving, and we'll see what happens with Morningstar, and we'll see if there are other sort of ESG ranking services that are using data that is, from sources that are anti-Israel.
Returning to the Ben and Jerry's situation, another audience member asks, presumably Unilever is very concerned to mitigate the risk of further reputational damage. What legal options does the parent company, Unilever or Canopco, have to take control from the Ben and Jerry's board, especially 22 years after the acquisition agreement?
If Unilever could get rid of the independent board, I'm sure they would, especially after what's happened in the last couple of years, but they don't have the ability to do that. The merger agreement and the contracts around it create this board that can't be undone. These arrangements can't be undone. These independent directors can appoint their successors, as I said. And if Unilever were to sell Ben and Jerry's to another company, that company would have to abide by the same arrangement. So there's no way that Unilever can get rid of the independent board or any company buying Ben and Jerry's from Unilever. They're stuck with it.
I can see that in a share sale position. What about in an asset sale, where, much like the sale to Avizinga of certain trademarks and other intellectual property, you strip out some of what makes Ben and Jerry's. Would there be any barriers to selling, that you're aware of at least, to just selling off the rest of the Ben and Jerry's intellectual property, such that this board is left with a shell company directing it as it wants, but not really having any power over anything important?
Yeah, well, I don't have the merger agreement in front of me, so I can't answer the question. If the merger agreement was written carefully by the lawyers representing the individuals Ben and Jerry, they would have put in language that would prevent Unilever from circumventing the arrangement by doing an asset sale.
Understood. Do stock exchanges have rules against dysfunctional corporate structures? For example, where a parent can't control an errant subsidiary? And if so, are they ever enforced? The questioner is, of course, referring to the types of controls which might be said to apply to Unilever. If they are not being enforced, these types of controls, do you think they should be?
Okay, so Unilever is listed in the UK and also listed in New York, I think on the New York Stock Exchange. So I don't know what rules the UK exchange has, so I'll just talk about the New York Stock Exchange. First of all, the New York Stock Exchange has very limited rules, even as they apply to American companies. When it's a foreign company, there are even fewer rules. And then even when there are rules, exchanges are reluctant to enforce them because the exchange is a business. And if you enforce a rule against a company and cause it to delist, or just give it trouble, other companies are not going to want to list on your exchange. So the exchanges have very limited rules. There's certainly nothing that prevents a company from having an errant subsidiary. That would be a sort of a strange rule to have, since there seems to be only one company in the universe that has such an arrangement. And even if the New York Stock Exchange had such a rule, they would not really want to enforce it because they don't want to kick Unilever off of the exchange. They'll lose money.
Aside from the situation in the US, which, as you have emphasized is a difficult one for the BDS movement. You mentioned that Europe is potentially more fertile ground as far as they're concerned. And one of the audience members has asked about new legislation in Europe, which they say will be increasing corporate social responsibility standards and may be used to attack Israel in the future. Is that something of which you're aware, and can you give any kind of comment on what the status of that legislation is, and what might the consequences be?
You know, we Americans are extremely parochial. We're very inwardly focused on America, so I'm not really tracking what's happening in Europe. But I am sort of aware of these regulatory efforts to get companies to be more socially responsible. And I am worried that the BDS movement will use any such regulations to try to get companies to move out of Israel. And even if they fail, they can use the engagement with the company to demonize Israel. Because in the end, you know, one of the objectives of the BDS movement is to turn, you know, many people in many different countries against Israel, so that Israel loses, you know, its outside support.
So building on that point which you just made about the wider aims of the BDS movement, what do you see as being the effect, if anything, one audience member asks, on the chances of peace and normalization between Israel and the Palestinians and other peoples of the Middle East? Speaking, for example, in the context of the Abraham Accords, which are widely seen as having been a significant breakthrough in terms of the outward normalization with many other Arab Muslim countries.
Is the question like, how is the BDS movement affected by the normalization with the Abraham Accord countries?
Well, I think two ways. So, how is the BDS movement affected by it, but also how what effect is the BDS movement likely to have on the further normalization of or lack thereof of relations? Will the BDS movement stymie these efforts, or do you think that the efforts of normalization are likely to be stronger in the long term?
So the BDS movement operates in Europe and the United States. They may also operate in South America, I'm not sure. They sort of operate outside of the Middle East to turn people in countries outside of the Middle East against Israel, because they understand that, you know, Israel is basically an island, and if it gets cut off from the rest of the world, it's going to be in big trouble. So the BDS movement is not operating in Egypt, Jordan, Saudi Arabia. They have enough anti-Israel and anti-Semitic sentiment, you know, to last them a millennium. The BDS movement is not going to be able to add any value there. They're focusing their efforts in places where there is some support for Israel, or a lot of support for Israel, to try to erode it. So obviously the BDS movement had no effect on the Abraham Accord countries agreeing to normalize with Israel. And in terms of further normalizations, which I hope will happen, they're not going to have any effect, because they're not really operating there.
Another questioner asks, why do you think it was that Unilever changed its original position, which it held for around a year, as I understand matters, that it could not override the decision of the Ben & Jerry's board, and then subsequently took the decision to sell the IP to Mr. Zinger, as you were describing? What do you think caused that change, to the extent that you haven't covered this point already?
Yeah, so I'm just I'm just guessing because I don't know what happened in the Unilever board and the conversations between Nelson Peltz and the CEO of Unilever. But my sense is the single most important factor was Nelson Peltz showing up and putting pressure on the board to find a solution. However, he didn't seem to show up until mid to late 2021. And it seems that at the time of the boycott announcement, Unilever was trying to figure out some way of allowing Zinger to sell Ben and Jerry's ice cream in Israel. And hence that sort of cryptic line that, Ben and Jerry's will remain in Israel, which the Ben and Jerry's board did not want put in the press release, but the Unilever appointed CEO put it anyways. So, it's possible that Unilever was all along planning to reach the solution that it did, but it hadn't worked out all the details. And all of these things that were happening on the outside, the lawsuits, the pressure from the Israeli antitrust agency, Nelson Peltz, that didn't have much effect, but I'm sort of skeptical of that. I think the Nelson Peltz was probably the most important factor, followed by the lawsuits and the divestments.
We are getting to the end of our allotted time, but perhaps I can just ask one last question, touching on the point that you just made about the importance of Nelson Peltz. Now, clearly the amounts of Nelson Peltzes in this world are not many. What are the things that the members of the public who support Israel and lawyers can do to counter the BDS movements?
Well, members of the public can, write letters to newspapers in response to hostile letters or hostile editorials. They can make sure that schools in their towns are not teaching anti-Israel material. They can, if they're in the United States, contact their representative in Washington and make, clear their interest in fighting BDS. So that's what members of the public can do. There are many ways that lawyers can fight BDS through lawsuits or filing complaints. We have a lot of that in the United States. I didn't have time to get into it. But the thing here is that we don't really need Nelson Peltzes generally. Nelson Peltz might have been needed in this situation, but only because of the weird governance arrangement in Unilever that allowed a bunch of people to go rogue. Generally, companies are not going to do what the Ben and Jerry's independent board did because of the repercussions.
Professor Fried, thank you so much for a really informative and interesting and thought-provoking talk. It's been fantastic hearing your insights on this. Thank you to everyone who has joined, and thank you for your fantastic questions. I'd also like to thank again the kind sponsors of this event. The next UKLFI Charitable Trust event will be on the 8th of September, Thursday, at 5 p.m. UK time, 7 p.m. Israel time, 6 p.m. Europe, and noon USA East Coast. The event will be titled The Trojan Bourse with Dan Harris, who is a leading specialist in financial markets, talking about his new book, which analyzes how the BDS movement seeks to influence divestment and exclusion of stocks from investment portfolios. So very much along the lines of the issues that we touched on today, particularly with respect to the recent Morningstar saga. We very much hope you can join. Thank you all again. Thank you, Professor Fried.